afternoon, Your Honor. Robert Cosgrove from Commonwealth.
Good afternoon.
Hello, Your Honor. Timothy Bradl on behalf of Aidan Kearney. To my left.
Good afternoon. Good afternoon, Mr. Kearney.
And Mark Bederow, Mr. Kearney.
Hi, Mr. Bederow. Good afternoon. Okay, let's arraign him on the new case.
On May 13th, 2025, the grand jury sitting in the County of Norfolk returned indictment number 2582CR00088 charging as follows. Offense 1, charging intimidation of a witness, and offense 2, charging intimidation of a witness. Do you wish to waive the full reading of these indictments?
Yes.
How do you wish to plead to each of these indictments?
Not here.
Thank you, sir. Is there a question of bail?
There's no question of bail, but I would ask the court to impose the same conditions that were imposed in the Stowe District Court. And Mr. Bradl, correct me if my memory is wrong. I believe it was no contact with the alleged victim and stay 100 yards away from his place of work and residence.
What are the allegations on these, on this one?
Intimidation of a witness, Your Honor.
Yeah, but what's the nature of it?
This was the appearance outside.
Oh, outside
the
the
shop.
waving in the
Yes,
pieces.
correct.
Yeah, I remember. That's fine.
Judge, that's agreed under Section 87.
Yeah, that's fine. All right, I'll impose that, Margaret.
Thank you.
Would you like me to do that now? Wait.
Why don't you do that now? Just do them one
Mr.
at a
Kearney, the
time.
court recognizes the person without assuring the following conditions. You will have no contact record on record of the victim in this case. You are to stay away, have no contact, stay away 100 yards from the residence and the place of work of the complainant. Do you consent to those conditions, sir?
Yes.
You are hereby notified if you're charged with a crime during the period of your release. The bail in this matter may be revoked in accordance with maximum allowed to 276 section of the state.
All right, what else are we going to do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay.
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
Okay.
There is not.
Yeah, those are both ordered. So we saw it, the Commonwealth sought it to preserve notes of investigators and to preserve video. What else can I do for you?
For me or for Mr.
Why don't I
Bradl?
start with you, Mr. Cosgrove? Go right ahead.
So Your Honor, answered the discovery order the last time we were here. I made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Bradl today. And I had planned, Your Honor, to file that with a motion for a protective order, which I had served on Mr. Bradl a couple of nights from when I gave Mr. Bradl. And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicate to the discovery turned over in the Karen Reed case, and I pretty much follow their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradl wishes to bring that practice to an end as of today. I'm in a somewhat different position.
All right, let me hear from Mr. Bradl. Mr. Bradl,
Thank you, Your Honor.
give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moved. It's gone. Okay? And my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it, but I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents. And that's really all the Commonwealth has left on the existing stuff, is that, you know, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, you know, cause election shifts, you know, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, you know, from the Commonwealth, and when they say, just, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor, you know. This is a case of immense public interest. This is a case of, you know, First Amendment issues, and I know we may disagree on that, but, you know, that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC of the Supreme Court starts with a trial judge maybe not agreeing with it, so that's okay. And, you know, that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and, you know, these text messages about, you know, and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to, you know, publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other, and the content of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a
Yeah, I'd give you that. Was a week enough?
I'd like a little more than that.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradl, Mr. Bederow, you absolutely have every opportunity.
Thank you very much,
Okay.
Your Honor.
Now, Your Honor, with respect to the items that I was going to turn over today,
So I'll allow the motion. Mr. Bradl, I'm up here.
Sorry, Your Honor.
Sorry.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Bederow. My point is this: if you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
Please note our objection. Thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very much.
Does that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And I want to start off, I know that the court's time can be much better spent in discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out,
Yeah.
you know, I think we're going to agree to go in person with our people and figure it out. So
Yeah, sure.
that's the first thing I want to say. But then, in addition, Your Honor, there's this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with our Third Motion to Compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, you know, were the months following. And you know, in fairness, counsel for the Commonwealth was not the prosecutor of record at the time. But, you know, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important. maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
Can you give me an extra week? Or?
Give me an extra week.
Thank you.
All right. But it is, Mr. Bradl makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradl has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery turned over in this case.
Yeah. If you turn over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay,
So,
great.
Thank you. And Attorney Bederow has a number of items as well, Judge.
Mr. Bederow.
Thank you, Judge. Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment. Specifically, messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware, Michael Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Kearney's interest and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has, the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded at this time.
Okay. Anything you want to say to that, Mr. President? Not going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other one.
I think that makes sense.
I won't ask for another week. I won't ask for another day.
That's, why don't I do this? Why don't you all come up to sidebar? Let me take a look.
Your Honor, may Mr. Kearney join us?
Mr. Bederow, the floor is yours. What else?
Thank you. Judge, one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025 For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. 𝗏𝗀 will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness, and we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. 𝗏𝗀 to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him as a witness.
Mr. Cosgrove.
Could I inquire if Mr. 𝗏𝗀 is online?
I do not see him. Attorney 𝗏𝗀, last time you used his name, there was no one with his name.
Can I approach?
Of course, come on up. Mr. Bederow, you said you had one more thing.
Yes, Judge. Just as it relates to discovery, we have made a series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state police and the district attorney's office regarding her very unique relationship in all matters involving Mr. Kearney. Those demands, which again are in the files, Mr. Cosgrove has them outlined in detail, her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Kearney, voice recordings that she has left Mr. Kearney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. 𝗏𝗀. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is obligated to do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, 𝗬𝗏𝗂𝗏, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Kearney's case and may or may not have had a relationship with her too. She has made statements allegedly indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't think that that has happened. We respectfully submit that is something that Mr. Cosgrove has to do. In particular, I would draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Kearney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real. They're obligated to do it, and we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
Okay, Mr. President.
No, it's largely been done.
Is that part of the 5,000 pages that you're turning over?
It is, among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha. Okay, that's fine. So that seems to solve that. You said that you had some things you wanted to bring up. Go right ahead.
Yes, yes. So this will be an opportunity, Your Honor, for myself and Mr. Bederow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time, it was initially filed provisionally without hearing from the Commonwealth. Was impounded upon, I believe, not the affiant's representation, but I think Mr. Bradl's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe an affiant should be allowed to accuse an assistant DA of jury tampering and a district attorney of having secret meetings with witnesses and all these other things, and then hide behind an impoundment order.
Okay. Let me hear from the other side. Mr. Bederow.
Yes, a couple things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do, and at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement, and almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more then appropriate.
Okay.
Just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay. If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at this one point, the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say is that the identity of this person is all over the internet, and was all over the internet at the time and was before you the other day. I don't know what the interest is, given those circumstances, in concealing it in the court papers.
Judge, I'm sorry, what?
And I'm sorry.
I'm sorry, go ahead.
Could I just add one thing?
Yeah, go ahead.
Apparently these things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time, first of all, that event was publicized by Mr. Kearney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay.
Just very quickly, Your Honor, in terms of this individual's name being on the internet, there are 2 reasons for that. The first is because Ms. Peter identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally, through no fault, with no malintent, is not a reason I think you just open up the affidavit to her name.
Okay, thank you all. So we have a date for, who was it, August? What was the date, man?
August 13th.
August 13th. And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yes,
What's the
you
end
want
of
to
the
pick it
month?
now, or do you want to pick it on the?
Why don't we pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be standing.
That's okay.
I may have some information about
That's fine.
the health status at that time.
All right.
so.
We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
I'm sorry. I believe we have an agreement. Mr. Bradl has responded relative to the source code for accessing the search of the devices.
Yes.
And he's indicated that it was the same source code previously provided to Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
Sure,
And I
Mr.
don't think
Wood.
there's a disagreement with that.
All right. You don't
That's
disagree
agreed,
with that, do
Your
you?
Honor. Sure, yeah.
All right. I'll see you August 13th.
Thank you.
All right,
Thank you.
take care. Bye.
August 13th.